Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Patricia J. Millen presiding.
Good morning. You may be seated.
Thank you.
Well, our first case today is Robert White versus CBI Services, the Liberty Mutual Insurance. Workers' comp number file WC 24-6570. Today's date is February 3rd, 2025. We are here live stream and also listening. I have representatives of CBI Services.
Yes, Your Honor.
We both have 15 minutes. Today, we will start out with 3 minutes. After that, are there any questions before you?
Nothing here, Judge.
Mr. Bonner, can you proceed?
May it please the court. Under the terms of a stipulation for settlement filed in 2005, the insurer was to pay a $55,000 lump sum payment within 14 days. And there were specific periodic payments, 5 of them identified for future payment out of an annuity purchase. And future medical was left open under this settlement. The employee received his $55,000 on a timely basis within 14 days, and he timely received his initial 3 periodic payments. The employee has not received the $10,000 payment due December 26, 2018, nor the $17,940 payment due December 26, 2023. Employees Counsel wrote a letter to the insurance company on April 10, 2023, asking about the late payment that was due on December 26, 2018. Employees Counsel then filed a claim petition on July 25th, 2023. And at the hearing of April 23rd, 2024, the employee testified that not only had he not received his 2018 check, but he had now not received his check due on December 26, 2023. At the hearing, the insurance company offered no explanation as to why the checks were not issued. The employee, I can tell you, still has not received payment. The employee therefore claims payment of penalties and interest against Liberty Mutual, the insurer itself. The compensation judge and my opponent find that the insurer discharged its duty by paying the initial $55,000 on a timely basis within 14 days, that the insurer made arrangements for this annuity to be purchased, and that the employee allowed the insurer to assign its duties and obligations to pay future payments through an annuity. And therefore, the insurance company is not liable for payment of penalties. I offer 3 arguments as to why the insurer in this case should be assessed penalties. Number 1, under 176.221, subdivisions 8 and subdivision 6 require that all compensation be paid on a timely basis, regardless of who issues the payments.
Which allows the employer insured to relieve of their responsibility for payment penalties.
To be relieved of their responsibility. That's precisely my argument, is that they cannot be relieved of the,
statute or case law that you would suggest? Because I understand what the statute and the parties cannot be not have allowed by statute. Can you point to place in the statute that allow the application of that responsibility by the employer?
nowhere in the statute is that abrogated. That is correct. The second argument I have is that while the parties did agree to allow the insurance company to assign duties and obligations to pay periodic payments, compensation that arise from the work injury, in fact, they did not bargain away the insurance company's obligation and duties to pay penalties down the road should payments be issued on an untimely basis. And then finally, an award of penalties will support the public policy to have trust and confidence in workers' compensation settlements, that they be paid on a timely basis. The argument number one, the award on stipulation.
Go there. I'm going to ask you a similar question to what Chief Miller asked. And Mr. Michael, one of us would probably ask this question as well. You said there's nothing in the statute that abrogates obligation to pay penalties or stuff. In your brief, you actually concede the obligation of the employer or insurer to pay the underlying. So I understand they have not been paid. There are certain things near the Workers' Compensation Act that cannot be contracted. An employee cannot contract away their status as an employee. Jurisdiction. Do you have an argument that perhaps an employer's obligation can also not be contracted away?
The compensation, which is a direct result of the injury itself, under the Hop case, that I don't know that I would be comfortable using contracted away. Insurance companies often make arrangements for various persons to make payments. I think that's very common. That's not contracting away their responsibility to make sure compensation is in fact paid.
But just because they're made, is the employer and insurer then off the hook? Or should they be the final guarantor under the statute to make the payment?
The employee has not at this point made a claim in this case that Liberty Mutual should now be making payments. That's another argument, and that's not what we claimed at the hearing. We are claiming that penalties are completely separate from compensation, and penalties cannot, in fact, be bargained away from the act, away from the insurance company. Under subdivision 8 of 176.221, which is cited in the award by the compensation judge in 2005, quote, that statute states, quote, all payment of compensation shall be made within 14 days of the filing of an appropriate order, unless the order is appealed or if a different time period is provided by this chapter. I'll focus first on different time period. The periodic payments approved by the compensation judge in 2005, in fact, provide not only a $55,000 payment within 14 days, but 5 additional periodic payments. So we're talking about different time periods of payment that specifically subdivision 8 references. The insurance company is not simply restricted to 14 days of payment if the stipulation for settlement provides otherwise, or if the law provides otherwise. And those 5 annuity payments became the law of this case once they were specifically identified in the stipulation for settlement. The other phrase I will focus on in subdivision 8 is the opening phrase of all payment of compensation. All the compensation in this case involved not only the $55,000, but the 5 remaining periodic payments that the annuity was to pay. So the compensation judge, by focusing on the fact that the initial $55,000 payment was issued and therefore fulfilled its obligations, That is not all payment of compensation, which the compensation judge in 2005 ordered should be paid on a timely basis. Subdivision 6 of 176.221, I will bring to the court's attention. It reads, quote, "The insurer is liable for a penalty payment assessed against it, even if the delay is attributable to the employer," end quote. The reason I bring that up is because the compensation judge's findings and orders seem to suggest that the insurance company was not responsible to issue payment, therefore is not responsible for penalties. But the statute already contemplates the very idea that just because it could be the employer that's at fault in not issuing the payments, the insurance company is explicitly responsible for penalties even under those circumstances. So it's not novel. Yes.
Excuse me, 1 second. You need to come off of mute. They're having a hard time hearing you.
There you go. Thank you. Well, I guess I won't be on TikTok. I have a question for you. And I'm going back to the compromise and release agreement. Where in that agreement is the penalty assigned? Because I don't see it. I don't see a penalty assigned into the release. I see the funds and it's not there. So is it then transferred?
Is what
Penalty, right.
No, the uniform agreement can only issue payment for compensation connected directly to the work injury.
You're on mute too, Kathy. Push the button. There you go.
I'll reserve 2 minutes of time.
I'm sorry, Mr. Von Ruder.
Yes,
We
so
have some technical difficulties and it's operator error and I'm the operator.
technology is a blessing and a headache.
So I asked, where's the transfer of penalties in the transfer of the funds in this annuity agreement on the condition, the release? Because I don't see it.
You don't see it because there is none.
Okay.
In fact, it's not even conceptually possible to transfer penalty exposure to another entity because the entity is paying compensation attributable to damages related to the work injury itself. Penalties are an entirely different set of monetary payment. They're connected to a public policy to ensure and enforce timely payment, but penalties are not directly tied to compensation related to the work injury.
So it's not transferred, and does it then stay with the rights and obligations of the insurer and employer?
Yes. Yeah. At the end of the day, the insurance company is the party to this case. The employee would not be able to sue in district court for penalties under this chapter because that judge has no jurisdiction. This is the only recourse the employee has for penalties and interest. And that's why the insurance company, the party to this case, belongs here with an assessment of penalties.
And my question is, who owes the money to your client? Is it the employer and the insurer, or is it the annuity company?
I suspect it's our definition of who, did you say owns, Your Honor?
Oh, who owes?
Who owes, right, who owes? Well, I think that the common sense answer to that is clearly the annuity company, Liberty Assurance Organization or something like that. They owe the money. Again, that's why at the hearing before the compensation judge, we did not claim payment of the compensation directly against Liberty Mutual. It's the annuity company that owes the money to the employee.
And my next question is, and I'm not sure if I have the document itself, but there was some email. It's OAH 34 is the number of the document. And it looks like it's an email, and it talks about a guarantee running from Liberty Mutual, guaranteeing the performance of Liberty Life Insurance Company of Boston, the annuity issuer. And was there a guarantee made as set forth in that email that we don't have, that you're aware of?
A guarantee that the annuity company would make the payments?
No, guarantee that, the way I read it would be Liberty Mutual would guarantee the payment made by the annuity carrier.
Quite frankly, I don't know the answer to that question. I don't know that I've not seen a guarantee that Liberty Mutual, the work comp insurer, backs up the payment. The the Hop case is what I would suggest creates this distinction between compensation and penalties. Penalties is really a mechanism to enforce timely payment of benefits. That should never, an insurer connected to a workers' compensation case should never be relieved, and I would argue cannot be relieved to ensure that timely payments are issued. It doesn't matter if it's their bank that issued the check incorrectly. It doesn't matter if some other person, such as the insurance company's attorney, made a mistake. It doesn't matter if it's a third-party administrator. At the end of the day, the work comp insurer is always responsible for the late payments. The insurer can always come forward with a reasonable explanation or an excuse as to why the benefits weren't paid. That's part of the process of assessing penalties. This case is particularly egregious because there's been absolutely no reason given as to why the payments are delayed. To this day, we don't understand why they're not paid. The workers' compensation insurer has that obligation to account for why the payments haven't been made. And that's the heart of why we assess penalties to begin with and why penalties should be assessed in this case.
And just so I'm clear, so you're not, in terms of the appeal in front of us, you're not making any claim that the payments are due, the $10,000 and the $17,940. It's strictly the penalties that are due your client for failure to make those payments.
Well, the compensation is owed to the employee. Quite frankly, because the annuity company is not a party to the workers' compensation case, I believe a declaratory judgment would need to be filed in district court in order to enforce that payment. Otherwise, the jurisdiction of this court would involve ordering Liberty Mutual, the work comp insurer, to make payments. And that's a possible claim as well. Minimally, they should be required to pay penalties. I'm sorry, I couldn't hear you, Judge.
Has any contact been made by you or your client to the S&E in this case?
That's a good question because this contract that the employee signed provides a mechanism for a replacement payment if the benefits aren't paid. We don't know who the bank is. We don't have an address. We don't have a phone number. That's why I took the reasonable step of writing a letter to the insurance company asking about the information, filing a claim petition, and we just don't, the employee doesn't know whom to contact. It's not anywhere in the paperwork. I will reserve the remainder of my time. Thank you.
Do you have any questions? Anybody else have any questions?
No, thank you.
Nope.
Thank you.
These now. Good morning, and may it please the court, Mr. Von Reuter. I represent the employer and insurer in connection with this matter. I've known Mr. Von Reuter we went to law school together, and I think between the two of us, we have about 50 years of combined experience. And based upon the conversations that I've had both before and after last year's hearing, I think we're in agreement that neither of us have ever seen anything like this before. Digging around, trying to come up with case law, both in preparation for the hearing and for today, reveals that I don't know that the court has dealt with a situation very similar to this, or if at all similar to this in the past, which is what brings us here today. And what's also interesting about this case is that we agree with about 98% of what's gone on in this case over the past couple of decades. That it was a reasonable settlement, there was no mistake of fact, there were no ambiguities in the STIP, that the vast majority of the obligations, if not all of the obligations, which is where we get to the rub, were satisfied by my clients. It's only some 15 or so years after the settlement that these final two annuity payments were not received, and that's what brings us here today. And of course, I gathered a little bit of insight from some of the questions you were asking, Mr. Von Reuter, as to where the court is maybe focusing on in terms of how do we resolve this dispute. And I think fundamentally it comes down to what were the obligations under the stipulation for settlement. When you look at the statutory language regarding the obligations of an employer and insurer, it essentially says basically they have 14 days to make good on their obligations under the stipulation for settlement, which I believe we stipulated that my clients did. They paid the initial $38,000 to the employee, as is referenced in the notice of benefit payment. They paid Mr. Von Reuter his fees and costs, and it's undisputed that they funded the $25,000 settlement, or the $25,000 annuity that was part of the settlement. Interestingly, counsel indicated during his time earlier that when this was approved, this settlement was approved by the late Judge Ellefson, that he, in essence, ordered these precise payments that were part of the annuity. But if you look in the stipulation for settlement, nowhere does it indicate in the actual body of the stipulation that these 5 precise payments were to be issued. No, it doesn't. Rather, what it says is that the annuity is to be funded in the amount of $25,000. So when this case was approved by Judge Ellefson, within 14 days, my client paid Mr. Von Reuter, paid Mr. Mike, funded the annuity, which is also evidenced by the fact that the first 3 payments were issued, and in essence, at that point, satisfied any obligations that it has that can be imposed upon it by the jurisdiction of the Office of Administrative Hearings.
I'm going to
This
interrupt
court.
you a minute.
Yes, of
Thank
course,
you.
Judge.
Can you point to any statutory provision or case law that relieves your clients of the obligations under the penalties provision of 176?
I cannot point to anything statutory or case law that specifically indicates as much. I can only point to the fact that penalties can only be issued for non-compliance with an order of this court or of the Office of Administrative Hearings, which gets back down to that fundamental question, what exactly was ordered after the approval of the settlement?
You know, Mr. Schmeichel, this is what bothers me. We have, no doubt, everything you said is accurate. Your client funded the annuity. True. And I know you weren't involved in the original settlement. But, you know, the public policy of the comp statute is that the benefits are to be paid in a timely manner at a reasonable expense to the employer insurer. The benefits weren't paid. You know, I realize maybe your specific client didn't do it, but whoever they purchased the annuity from, which sounds like it's another Liberty outfit, but I don't know the relationship. When that isn't made, isn't the statute then being ignored, as it were? The purpose of the statute isn't being fulfilled when the benefits aren't actually paid.
I understand your question, Judge. And again, there's no doubt that Mr. Mike did not receive the final 2 payments, and I agree with counsel that.
Well, there
he's
was doubt at the trial.
Pardon me?
In the trial transcript, you said the employee says he didn't get them. And then if you go back to the trial transcript, there's questions by you that suggests that perhaps the employee is incorrect in that statement by inference. Is that a fair analysis?
I did ask the questions during the hearing as to whether he had changed address, and he had
You did.
satisfied my curiosity. And I believe that the compensation judge also indicated, or by not mentioning it, was satisfied that in fact payments, that he was credible in his testimony that payments had not been received.
But you raised that issue by inference that perhaps that should be questioned. And you basically could not make the statement that you yourself had investigated, but that you were willing to cooperate to see if in fact those payments had been made. Is that a fair statement?
Yes, that is a fair statement, and that goes to Judge Sundquist's question as to was the annuity company ever contacted, and I believe counsel indicated that he and his client sought some information, and I can advise the court as an officer of the court that I too spent hours on the phone trying to track this down. and Justice Quinn, this goes back to a question that you had asked regarding, uh, who exactly, that if my client purchased this annuity and arranged the annuity, then shouldn't my client, in essence, be, if you set all else aside, shouldn't they be on the hooks for penalties if whatever they purchased didn't come through? But if you look at the evidence that was submitted in court, particularly counsel's exhibits, this annuity was purchased together. The parties went together to find this annuity and to set up the annuity payments, to look at the contracts. And in essence, this wasn't a unilateral negotiation for this annuity.
But I see two separate issues here under the Uniform Qualified Assignment and Release. You transfer the payments. There's nowhere in that release that I can find where you transferred penalties.
Yeah, and you're right, Judge. There isn't anywhere that talks about what does happen if the payments aren't made. Interestingly, I think when counsel now concedes that the court may not and likely does not have jurisdiction to order a third-party annuity company to make the payments, even though the payments might be owed, that might be a district court action that they'd have to go with. Well, there are penalties that go along with not the traditional penalties under the work comp statute, but if you're bringing the action in district court saying, you've owed my guy a lot of money, you had an obligation to pay it, the annuity company, there's interest on those payments. And
I'm going to stop you there because the judge held the record open for approximately 30 days for both of you to submit closing arguments. Those closing arguments were part of the record.
yes,
And I want to read something that you stated in your closing argument here. Liberty Mutual Insurance is the only named insurer to this claim. Liberty Assignment Corporation is not a named party to this matter, nor could it be, as it is not an entity that provides workers' compensation insurance in Minnesota at the time of the 2003 injury or at any time since then. Thus, the evidence clearly indicates that 1, the employee acknowledged that liability for payments per the annuity fall to Liberty Assignment Corporation, and 2, Liberty Assignment is not and cannot be a party to a Minnesota workers' compensation claim. Do you still believe that to be true?
absolutely, Judge.
So do I. So where does your obligation for the payment of penalties move to be relieved under the Act or this case law?
Under
The provisions of penalties. It's not in the additional release.
and I understand what you're asking, Judge. It goes to the very definition of penalties, that penalties, as counsel agreed, penalties are for an insurance company or the employer's failure to make a payment or to take some other action that is mandated and dictated by this court, in this case, Judge Ellefson. When he signed off on the STIP, they were very specific and delineated. And I understand this is where the compensation judge sort of rested her hat in terms of reaching her decisions, is that penalties are to penalize for not doing something that you were ordered to do.
You know, your playbook is very creative in your presentation. And it kind of has a feel of a 60C, the insolvency, and what the jurisdiction is for a court. Is Liberty Mutual Insurance insolvent?
Liberty Mutual Insurance is not insolvent.
Okay.
And I don't believe this falls necessarily under, and it was not an argument that was raised, but it's an interesting question, Judge, as to whether if there was an agreement, like there was in this case, with a totally separate annuity company, if that company goes insolvent, does it then go back to the obligation?
Well,
of
I'm just
Liberty
looking at the
Mutual?
party that Mr. Von Ruder can attach under 176 to being a claim for penalties.
Right. Yeah, and I think that in terms of right now, the way I think it's just my client, that they can, in terms of penalties payable by, in connection with this matter. And so, again, my client didn't do or did everything that it was supposed to do pursuant to the terms of the agreement and pursuant to Judge Ellefson's order. And there's a separate entity that failed to make the payment that's still there's no evidence to suggest it's not a viable
Mis-
entity
Mr.
and it's
Schmeichel.
not out there somewhere.
Let me just interrupt really quickly. Wait, I'm going to not talk about penalties. I want to talk about the compensation. Okay.
Okay.
How do we fix this? What's the remedy here? Because as I see it, the only party that can fix this is your client. Your client paying the employee what he is entitled to under the terms of the stipulation, and then your client going after the annuity company. Am I wrong?
Your Honor, I respectfully don't agree with
Okay,
that.
tell me how to fix it. How do we
Okay,
fix this?
I think that in the realm within the chapter 176, or just how do we fix this situation? I think within 176, quite frankly, and I know it's a lot of hassle, but a vacation of the stipulation for settlement might be one option. Overall,
And he wouldn't have any penalties or interest then, would he?
you would not. But again, that falls back to this whole issue that my clients, I know it's tough to say in this day, big insurance company has clean hands, but again, there isn't evidence there is no evidence to suggest what is kind of being suggested, which is, come on, they both have the name Liberty. This is all coming out of one pot. I represent to the court that that is not in fact true.
I want to make it clear, I'm not making that inference or direct analysis. What I'm
Okay.
asking is for the relief of obligations by your client, employer and insurer, under the statute, when there's a contract for the assignment, period.
Right.
And number two, if there isn't, then by agreement, even if the contract trumps public policy, there's no conference of that in the release agreement and the transfer to the assignee. It's only to the funds. The penalty never was transferred, nor does it allow to be transferred and relieve your client under 176. And I can't find any case law that suggests it does either. That's all I'm saying.
And I agree with you on both of those issues. Nowhere in either the, pull up the exhibits in here. Nowhere in the Uniform Qualified Assignment and Release, which follows the initial document, which is the compromise and release. So the compromise and release says that by signing this, you push that over. Everything then goes into the that uniform release, and that uniform release doesn't take into consideration. It doesn't have a provision that says, "Hey, what happens if the assignee or the assignor or any of those definitions? What happens if payment is in fact not issued?" But again, I want to go back to the fact that this was not a unilateral contract. This was a contract that was sought out. Quotes were given. There were conversations. I wasn't a party to it at the time, but all the parties looked at it. All the parties read it. Both sides have signed off on it, and had an opportunity to look to it and say, "Hey, what does happen if this third party that isn't under the jurisdiction of OAH? What happens if payment isn't issued?" I think that the natural consequence of that is the district court action that would say, "You were supposed to pay us via this contract, and you didn't pay us, and we want payment plus interest."
Or
Mr.
Mr. Schmeichel, you could be ordered to pay it, and then Liberty goes after the annuity company because Liberty is the one who contracted with the annuity company. So wouldn't it be just a natural, I guess, cause of action for a Liberty that to just seek reimbursement from the annuity company?
Well, Liberty and the employee contracted with and pursuant to the terms. I mean, it's stated on numerous occasions in both the compromise and release and in the document, the uniform qualified assignment and release. It states that the employer and insurer are absolved of liability having to do with any of that, and now it's a matter that's between Mr. Mike and the annuity company. But it was not a contract that was entered into just between, like, say, "Don't worry, Mr. Von Reuter, we've got this." and we just go out and we pick whoever we want, and we go to them, and we devise all the wording, and we put it all together, and we sign it, and then say, if you want your settlement, sign this. This was a contract that was entered into on equal footing and signed off on by both the employee and the annuity company.
I have several questions.
And I do too.
So,
We'll keep going.
right, so, Judge Sundquist asked you a question about what do we do to fix this?
Yes.
And your answer was, within the purview of 176, perhaps a stipulation or a petition to vacate. Outside, I take it your answer is sue in district court.
It is, Judge.
Okay, is there anything else to the how do we fix this answer then, in your opinion?
I mean, there is the way, as Judge Sundquist suggested, is that Liberty Mutual just says, hey, we've got this and we paid, and then we, contrary to the verbiage that's replete in the settlement documents that were executed and signed by Mr. Mike, we say, despite what all that says, we, Liberty Mutual, will step in, do this, and then the burden will fall to us.
And you disagree with that solution?
I disagree from a legal standpoint. I disagree that it's my client's obligation to make that step.
Okay, so then, Judge Christensen asked Mr. Von Ruder a question about this guarantee that was mentioned in an email. Was there a guarantee?
I didn't see any guarantee in the email, and I believe the email that was referenced was before all of the contracts were created, such that anything that was mentioned via an informal email was either trumped by or was woven into the ultimate contract, which is again the compromise and release, and then the uniform qualified release. So, yeah.
Then as to your argument earlier this morning was the stipulation does not actually specify the 5 payments, but simply says your client is to fund. But the stipulation does say fund the annuity as outlined in Exhibit C or something like that, which does outline that. And I assume that's attached to the stipulation. Doesn't that then support Mr. Von Ruder's argument that the stipulation says these payments are to be made?
And again, I'm not splitting hairs on this to be argumentative, and I'm not splitting hairs trying to say, aha, we have one small little sliver of light that we're clinging to. I think that's a huge distinction. There's a huge difference between, hey, employer and insurer, you guys will issue these payments, as opposed to, hey, employer and insurer, you guys will fund an annuity with a third party and they'll issue these payments. And again, I'm not playing with words on this. I think that's an important distinction. And in almost all settlements, we don't see too many of them these days, that use annuities, they're almost always, and that's kind of the point of an annuity, is to have a third party that comes in, manages the annuity, and issues the payments.
Okay, and then this is my last question, then I'll let Judge Carlson have her turn. You're the respondent here. This seems to me like it's a legal issue, which is sort of a de novo review. Do you agree or disagree with that?
I agree with you, Judge.
Okay.
Yes.
Thank you.
Mr. Schmeichel, I want to start with where I was asking Mr. Van Ruder your opinion, your thoughts on whether, and again, there are certain things that you cannot contract away under the Workers' Compensation Act. Again, whether or not your employee, jurisdiction, there's a list of things that you can't just say, we sign an agreement that says it is, therefore it is. My question for you, is it your position that an employer's obligation can be assigned or contracted away to another company, for example, by the way of an annuity?
And I agree, Judge, that it cannot. I recall a moment early in my practice where my client was going to be late in issuing some payments. And I recall contacting compliance down at the Department of Labor and Industry and saying, hey, you know what, just so no red flags come up, I've got an agreement with counsel that we can do this. And I remember being told in no uncertain terms that you can't contract that away. And I've taken that to heart since then, and that was probably 20 years ago. And again, this goes down to the distinction, though, is that we didn't contract away. If my client hadn't funded the annuity or hadn't paid the initial payments as ordered by Judge Ellefson, then absolutely they would
Well,
be subject to penalties.
And so certainly your client has not gotten what they paid for. And certainly Mr. Mike has not gotten, what he was promised. So,
Correct.
and the wrongdoers are not in this courtroom, right? So getting back to Judge Sundquist's question of how do you deal with this? 191 is probably doesn't totally completely apply, but usually as somebody picks it up under a temporary order while things are being sorted out. Do you see something like that? Could you see your client being obligated? If this court were to rule, for example, that this obligation for payment cannot be contracted away, it eventually comes back to you, you sort it out like a 191 situation. Would you see your client then doing like a temporary order payment to Mr. Mike?
I could see that being another avenue that the parties could jointly explore. Part of the problem that we've had with this, Your Honor, and counsel addressed this during his presentation, is that neither side has been able to come up with who this exactly is. It would be different if I think if we'd identified who currently holds the annuity and got somebody to answer their phone and say, yeah, here's the deal, is we screwed up. There was some paperwork that was lost. We're trying to reconstruct it. I don't know what their explanation would be, but we're working on it. In that case, I think it'd be a lot easier for my client to step up and say, tell you what, let's alter the term of the original agreement. We'd make the payment, but now we're the ones that need to be answered to in terms of getting what we bargained for. Because what you stated is exactly true, is that my clients, certainly not nearly as sympathetic as Mr. Mike, my clients also, they didn't want this. They didn't bargain for this. That's the reason why the insurance company, Liberty Mutual, doesn't handle and issue and administer these things, because they pay to have that done.
Well, and to be clear, I'm not anti-annuity. It's certainly in private practice. I like them, especially for younger clients, right? There's very good reasons to do it. But this is a situation that I always feared. It kind of gets out of your control when you're now bringing non-work comp entities into it. And I've always wondered this exact question: can you really contract away your obligation? And I think you answered that for me right away, that you agree that there are some things that cannot be contracted away, and ultimate obligation to pay is perhaps one of those things that cannot be contracted away. Would you agree with that?
I would agree with that. I think the only part that we disagree upon is what was the ultimate obligation. And I think that the parties sort of assumed responsibility pursuant to the terms of the annuity contracts as to what would happen if things went bad. And I think that the contracts are clear in that sense, that the employer and insurer was not, they were indemnified and left out of this.
Thank you.
So who owes the money?
The annuity company owes the money, and I would love to be able to track them down and get somebody to answer the phone. But it's the annuity company that owes the money.
And who is the annuity company?
The annuity company started off as Liberty
Life Insurance Company of Boston?
Yes, which I believe changed names and went over to some other entity, and I'm not sure if they sold their obligations, as often happens between companies. But both I and my paralegal spent hours on the phone, as I'm sure has Mr. Von Reuter, trying to figure out exactly who it is that holds this paper and is legally obligated to pay. Because
So if
it's
they were
certainly not
brought
Mr.
in-
Mike's obligation to eat the payment, and it's not my client's obligation to make another payment.
I have a question for you. So if the Liberty Mutual Insurance Company, which your name, but Liberty Assignment Corporation, the assignee, and Liberty Life Assurance Company of Boston, the annuity issuer, as recognized by you as the last known one, were to come in and be brought in by Mr. Von Reuter, could you represent those two parties, or would that be a conflict of interest
It would
to move them off and say, like you did in your closing argument, they can't be brought in.
It would absolutely be a conflict of interest, and to the extent that they could be brought in, I wouldn't be representing them. I represent Liberty Mutual Insurance Company in connection with this matter, and even if they were a subsidiary or still are some sort of separate subsidiary, they clearly delineate the difference between the employer and insurer and the various other entities that are associated with the annuity. Um, uh, my interests are, my client's interests are certainly not in lockstep with the interests of whatever this company is that didn't make the payment. With the exception of, we just want the payment made.
And my last question is, in terms of this guarantee, if you look at the compromise and release agreement, section 5, assignment and funding of periodic payment obligation, because now we have, it reads in the middle of subparagraph capital A, when the periodic payment obligation is assigned to Liberty Assignment Corporation, Liberty Life Assurance Company of Boston is represented that it will provide a written guarantee of such obligation, which appears to mean they're guaranteeing the payment, and that's the annuity company, and they also hold the guarantee to make the payment, at least if I'm reading that correctly. Would you agree?
I agree with that interpretation, and that's one of the reasons why I think the parties on any situation like this jointly try to find, I mean, you got to be able to count on these annuity, which I'm glad that this doesn't happen. And I'd never seen this before, because then there would be no confidence in settling a case via an annuity. This is certainly an outlier. But I agree with you, Your Honor, is that they are the ones that are saying, we will honor this. This is our obligation. And now we can't track them down.
Does anybody else have any questions?
Good, thank you.
Thank you.
Thank you very much.
Mr. Van Ruder, we kept Mr. Schmeichel up here for an additional 13 minutes. So if you'd like a few extra minutes to respond,
Thank you,
please
Judge
go
Moore.
forward.
Couple of points. The obligations to pay compensation were not contracted away. From the employee's perspective, it's a method of payment. From the insurance company's perspective, it's a method of payment. This is not contracting away obligations to pay compensation, particularly for purposes of assessing penalty liabilities. The remedy, how do we fix this? What can be done? How do we even avoid this situation? I would suggest that 176.221 subdivision 6, which states that the insurer is liable for penalties even if the employer is at fault for late payment. That statute also provides explicitly a mechanism for the insurance company to reach a subrogation interest against the employer directly if the insurer pays penalties. There is no reason why in this case, maybe it was in this case, why the insurer could not have created a clause in negotiating this annuity with the annuity company that says, hey, if you're late making payments and workers' compensation Minnesota law assesses a penalty against us, we are entitled to subrogation against you if you don't issue payment on a proper basis. So that's there, and quite frankly, just speculatively, it may be there. We don't know, but the insurer, that's at the end of the day, that's their headache to figure out how to either recoup it or to eat it. And the penalty should be paid either way. I wanted to mention that Mr. Schmeichel, my good friend, made a point that the stipulation for settlement does not specifically identify the different dates of payment that the statute orders payment on. But the stipulation for settlement in section 8, or rather section 7 on page 4, states that quote, in addition to the lump sum payment of $55,000, the insurer shall purchase an annuity providing for periodic payments to the employee as more fully outlined in Exhibit C, which do, in fact, specifically identify the dates for payment, which thereby invokes 176.221 subdivision 8, which is that payments can be made at different time intervals. That's all I have.
Does anybody have any questions? Nope. Thank you very much.
Thank you very much.
Thank you.
Pleasure to be here today.
I believe the record is officially closed. Thank you both very much for your compelling arguments. We'll have a decision out within 90 days. Have a good rest of the day.